Well, we now finally have an answer to the question that many of you have been asking, which is what can the police do about the protesters that are blocking roads and other key infrastructure around the UK? As this morning, police made the first use of the new powers under Section 7 of the widely debated Public Order Act of 2023, when they arrested 60 climate activists taking part in a new march outside Parliament. The police made a line across the road in front of the protesters and directed them off the road. Then they began making arrests, according to Just Stop Oil. Of course, many photographs and videos have been circulating of the officers making such arrests, and doubtless they will be met with some criticism. But as I seem to be repeating day after day on this channel, we can't have it both ways. We can't have the desire for police to take control of protesters that are blocking the roads and causing disruption, at the same time as criticise the police when they do make arrests, when they have the power to do so under Section 7 of the new Public Order Act. So let's take a look at Section 7 of this Act and see what it says. Section 7 of the new Public Order Act 2023 provides that a person commits an offence if they do an act which interferes with the use or operation of any key national infrastructure in England and Wales. And, so it's an inclusive two-part offence, they intend that act to interfere with the use or operation of such infrastructure or are reckless as to whether it will do so. Reckless simply meaning that they recognise there is a risk of this happening and they do so anyway. So the key wording here, as with any legislation, is what does key national infrastructure mean? Well, helpfully this is defined under subsection 6 to section 7 of this Act, which provides that the key national infrastructure includes the road transport infrastructure, so in other words, just the roads around the UK, the rail infrastructure, which will include any part of the railway, whether that is the tracks or the stations or anything else. Likewise, air transport infrastructure, that would include anything to do with the airports and anything to do with their runways and even access to and from the airports for that matter. Anything to do with harbour infrastructure, anything to do with oil, with gas, onshore gas exploration, production infrastructure, onshore electricity generation infrastructure, or newspaper printing infrastructure. And Section 8 makes even further provisions about these, which simply means that regulations under subsection 7 may make different provisions for different purposes, and may take the form of consequential, supplementary, incidental, transitional, transitory, or saving provisions. In other words, they can make any other regulations to have any other effect on any of these infrastructures that they so choose. So it's a fairly broadly defined offence. Now, not only that, it is also an either way offence, because whilst the what I had to giggle very slightly with the reference to the Magistrates' Court powers, for those of you that don't know, the magistrates were given greater powers, increased from 6 months to 12 months imprisonment, and then because of certain difficulties was reduced back down to 6 months. The wording of this has covered both scenarios, as it is or as it might become, by saying that on summary conviction, this is under subsection 3, that a person who commits an offence under subsection 1 is liable on summary conviction, that means in the Magistrates' Court, to imprisonment for a term not exceeding the general limit in a Magistrates' Court. I had to smile when I read this so that it covers both scenarios, whatever the general limit is for the Magistrates' Court, so it helps for not having to do much redrafting later on, or even insert the bits that change. As you read through these bits of legislation, you'll see sometimes there are definitions and changes and new bits of legislation come back and amend and change. That won't be necessary, because whatever the general limit is for the Magistrates' Court, if it so changes in the future, it will be that limit, or a fine, or both. But it's an either way offence, because under sub B of subsection 3, it provides that on conviction on indictment, so an indictment in the Crown Court, to imprisonment for a term not exceeding 12 months. So a prison term not exceeding 12 months, or a fine, or both. So, as I say, this is an either way offence, and this is one of the ways, not the only way, but one of the primary ways that we can determine whether this is a summary-only offence, which means it can only be heard in the Magistrates' Court, or it's an either way offence, meaning it can go either to the Magistrates' Court or to the Crown Court. So, as for the 60 odd, I'm quoting a news article here, so if that figure is wrong, forgive me, but I'm quoting 60 people arrested. They may or may not be charged, as the case might transpire, and they may or may not be tried in the Magistrates' Court if they are charged, or they may or may not be sent to the Crown Court if they believe that it was sufficient to exceed the powers of the Magistrates' Court. So what would happen there is, when it goes for the first hearing at the Magistrates' Court, there is a decision made on what we call allocation, which means it's decided whether it's allocated to the Magistrates' Court, i.e. they accept jurisdiction and the sufficient powers of the Magistrates' Court to sentence any individual should they be convicted, or whether or not it should go to the Crown Court. In the event that the sentence is likely to exceed that of the magistrate's powers and therefore should go to the Crown Court. But it also means something else. It also means that any individual who is charged and tried for this offence could elect Crown Court trial. So they will have the right to elect a trial by jury. And then we might end up in the position where if they do get tried and you end up with, let's say, for example, we ended up with a jury that have very strong beliefs one way or another, they will then be directed by the judge to ignore whatever their morals and beliefs are and follow the evidence and the law in the case. Meaning, if the evidence is proved that these people have committed this offence, then they should convict them. But obviously that is down to a jury to decide if indeed someone is charged and then they've elected Crown Court trial, or it's been allocated to the Crown Court at that hearing at the Magistrates' Court. So all of this will wind its way forward for the first exercise of this new offence by arrests by the police this morning of these protesters. Now, paraphrasing what some have been quoted in the press to say, it may not be obvious, but if you decide to protest on public highways without permission, then you may be arrested for it. Not every time, but more likely if you are part of an activist group. So on the one hand, whilst there are serious issues to debate here, such as climate change and the fundamental right to protest, many people clearly feel that there should be some limit to that right to protest and that it's not an absolute right without any limits at all. I.e., there should be a right to protest, but not to the extent that it brings the whole city to a standstill. But obviously there will be many different sides and points of view to each of these debates, and I'm not telling you which one to think and which one to agree with, but maybe you'll leave me your thoughts and your comments in the box below. Let me know on which side of this debate you fall, what you think of the new law, what you think of these new powers, and as always, thank you so much for watching.